is there is there any reason to merge the application of the interpretation, in other words, the application of the policy to the facts with good reason? Once you understand what it means, courts decided what it means.
Well, there's then the departure point in the analysis, which I'm going to come on to. So there's the interpretation of the policy, there's the assessment of whether there's been a departure and the extent of the departure, and that then goes into the good reason. And one could regard the first two together or distinct. We've obviously been dealing with them as part of the first and same question of interpretation. So I've dealt with my first point. The second, and the reason for the first point, is, as Lord Steyn observed at paragraph 24 of Re McFarland, policy statements are an important source of individual rights and corresponding duties, he said, and critically, and again I quote, the decision maker may depart from the policy, but until he has done so, the citizen is entitled to ask in a court of law whether he fairly comes within the language of the publicly announced policy. So the court must interpret, my lords, what the policy means before considering whether the decision maker has properly departed from it.
Yes.
The third point is that the role of the court in relation to the two questions is distinct. It is common ground that the interpretation of a policy is exclusively for the court. And you have my point on Hopkins Holmes as to why deference to expertise is not appropriate in ascertaining the meaning of the policy. By contrast, the role of the court in assessing good reason is to assess the reasoning of the decision maker. Yes, of course, affording some weight to its expertise and deciding if those reasons are cogent or compelling. That is a very different exercise, and there is a risk that merging, first of all, the departure question, and secondly, the good reason question, will make the court's delineation of its tasks far more difficult. Fourth, and relatedly, there is a need for careful consideration of where, analytically, deference comes in, if indeed it comes in at all. That is how the court can be properly satisfied that the government is subject to and operating under the rule of law. My second reply point is about Munjaz. My lords, there was a suggestion this morning that the rejection of the rationality standard for good reasons was not binding on this court because Lady Justice Hale, as she then was not followed in the appellate committee. That is wrong. She was not followed on the application of that test to the facts, but the appellate committee was very clear that it was accepting her articulation of the test and the rationale in terms of the difference between Wednesbury and good reason, and we see that in paragraphs 46 and 71 of Munjaz.
46 and 51?
71.
71, thank you.
Of Munjaz in the House of Lords?
Yes, my lords. And then finally, Snedden. The reliance on Snedden is misplaced. That case concerns the circumstances in which the Secretary of State can depart from the advice of the Parole Board regarding the transfer of prisoners to open conditions. And the Court of Appeal held that the test was rationality, and that was obviously right in that context. But that context involved, first of all, the Secretary of State for Justice as the primary decision maker, the Secretary of State receiving expert advice consistent with the process set out under the legislation, and then the Secretary of State deciding not to follow that advice. So Snedden had nothing to do with not following a policy or process. To the contrary, the process was followed in that case. The case is about not following advice in circumstances where the Secretary of State is the final and primary decision maker. And my lords, one might think that there is some irony in the respondent replying to this case and relying on Snedden, where in this appeal the very complaint is that Ravec did not receive, as I've been saying to you, the expert input that it was required under its own terms of reference and practice to receive. So the appropriate analogy here would be if Ravec had obtained the expert input from the RMB, but then decided not to follow it. And in that scenario, we entirely accept that we would be in the territory of rationality, but that is obviously not this case. And the respondents' attempt, we say, to translate the Snedden analysis into the present context is flatly contrary to Munjaz in both the Court of Appeal and the Supreme Court. My Lords, finally, the Court has heard detailed submissions on the law and evidence over the past 2 days, and obviously those submissions are very important. But, and I know the Court has this point, one must not forget the human dimension to this case. There is a person sitting behind me whose safety, whose security, and whose life is at stake. There is a person sitting behind me who is being told that he is getting a special, bespoke process when he knows and has experienced a process that is manifestly inferior in every respect. And one can see that from the clear terms of the decision letter which we addressed this afternoon in the closed session. My Lords, we do say that his presence here and throughout this appeal is a potent illustration, were one needed, of how much this appeal means to him and his family. My Lord, those are my reply submissions.
Anything else, Sir James? Thank you. Well, can I start by thanking counsel and solicitors and the parties for the concise way in which submissions have been addressed and the very focused and helpful submissions we've received. Plainly, we will take our time to consider our judgments. I'm afraid it is most unlikely that you will get any outcome before the Easter break, but we will try and do our work as quickly as we can. We understand the importance of the appeal. When we deliver the judgment, we will first let counsel have it in draft. Because of the confidentiality issues, it's likely that the ring for any draft judgment and any annex or redacted version of the draft judgment is going to be quite tight, so nobody should expect to see it. But if you do see it, it is only for the purposes of agreeing an order and costs and disposition, and for no other purpose, as you will all be well aware. And it's most important that those strictures are observed and that we only get typographical or corrections of fact, not any suggestions as to how we might rewrite our judgments that you would prefer. So if you deal with it like that, it's likely that the time you will get, because of the sensitivity of this case, will be very short indeed. So you had better have a team on all sides standing by. I don't expect leading counsel necessarily to be available to deal with this when it comes out, but you should on each side, you've got plenty of, if I may say so, plenty of lawyers. You should have a team standing by to deal with it within 24 hours at the absolute outside, basically at any time. We'll try and give you some notice so that you can get your A team, but if not, I'm afraid we will need to deal with it very quickly. Good. Well, with renewed thanks, that concludes these proceedings.
Court rise, please.